Franchise developers causing legal mistakes. Developers, legal mistakes. You have an attorney, but how are some franchise developers creating and causing bad decisions when you franchise your business? Coming up next, we're going to discuss the top 5 legal mistakes. These are the top 5 legal mistakes, and we're going to talk about them and go in depth. Hate creating suspense, but I'll list the top 5. We'll go into some more detail, and I'll explain to you how the issues even come up. How does a developer, a franchise developer, cause legal problems? Aren't the lawyers there to fix it or prevent it? Well, the top 5 legal mistakes they're causing, well, number 1, you have no attorney. Their attorney is not your attorney. 2, your trademarks are off track and you may not even know it. 3, your territory structure, it's so much more involved than just giving a franchisee a radius or a zone. There's real legal rights underlying your territory grants. And there's big legal problems that developers are overlooking. 4, your royalty structure. It's not built to scale. And it's not built to avoid future franchisee disputes. Number 5, your item 19. It's not built to support your franchise sales strategy. We'll discuss each of these. So how does the issue come up? Well, we work with franchisors all the time, and many times franchisors come to us 1, 2, 3 years after they launched, and they have issues, they have problems. If it's a retail-based business that sells and distributes product throughout the country, like Charles, the developer and team didn't preserve my rights to sell through alternative channels of distribution. If it's a restaurant or service-based business, or say a restaurant that has third-party delivery services, like Charles, we have certain conflicts among territories. What if a franchisee in territory A delivers product within the territory of another franchisee? So these territory disputes arise, and it's from a lack of planning, a lack of thought process. How does this come about? Well, this doesn't apply to every franchise developer, but the ones that are out there that tell you they do everything from A to Z, that you could work with their lawyer or their lawyer approves your FDD and everything else, what they're really doing is packaging a bundle of services that they're not qualified to offer. And if you're a developer out there and you do this, you disagree, well, come on our channel. And what they're doing is they think this is all just cookie cutter legal documents, but they don't understand how these documents are used over time. Sure, they're signed when you become a new franchisee or you take on a new franchisee, but what happens in litigation? What are arguments that franchisee attorneys attempt to make about territory protections, about your item 19, about your trademarks, about your royalty structure? They don't have a clue. So we need to plan ahead. And the mistakes that we're going to talk about, and as we go into more detail, not only do they create unnecessary legal liability or exposure, they're just bad franchise sales and growth strategy. And that's the most frustrating part. So mistake number 1, I don't even know if this really qualifies as a mistake, but it's sort of the root cause of all of this. You don't have an attorney. Again, this doesn't apply to every developer, but if they claim their attorney approves the documents or they have an in-house attorney, you do not have an attorney that's looking out for you. You do not have an attorney that's in an attorney-client privilege relationship with you. You do not have an attorney that's beholden and obligated to you over time, and they're not looking out for your best interest. So you need to be very careful. And then what makes it worse, and I even see this with franchisors in regulated industries like healthcare. It turns out when we dig deeper, there was no attorney at all. The developer was just reprinting legal documents that they're not prepared to fully understand. And as we talk about some of these other examples, you'll see why. Legal mistake number 2, your trademarks are off track. And this is frustrating because when you're a franchisor, one of the most important assets that you're going to be licensing to your franchisees are your trademarks. And if you already have registered trademarks, then that's great. And just have your legal counsel make sure they're maintained. But you go through a franchise development process. If you don't have your trademarks registered yet, the developer or whoever else may refer an attorney or may just file your trademarks. Now that's okay, but what the step that's missing is no one's evaluating your trademarks before they're filed. And why is this important? Because it takes about 10 months before the United States Patent and Trademark Office will even review your trademark application. So while you'll become a franchisor 90 days from now, it's going to be another 10 months before the government even looks at your United States Patent and Trademark Office application for registration of your trademarks. Well, why does this matter? 10 months from now, an examining attorney at the USPTO is going to review your trademark application. He or she is going to conduct a search to see if there's any confusingly similar marks that are already registered, and also evaluate whether or not your trade name or trademark is capable of protection. They'll go through an evaluation as to whether or not your mark is descriptive or suggestive. In most cases, 90% of the time, if we evaluate your trademarks today, we can anticipate 90% of what an examining attorney is going to decide and evaluate. That's part of what we do every day. One of the most important points when we're developing a franchise, we have a trademark analysis. We have a special meeting with our clients to go over their trademarks, preparing applications, but in addition to preparing them, evaluating the USPTO database to identify potential conflicts. Why? Because if there is a conflict that's obvious, we need to address it now. Why wait 10 months from now? If we need to consider rebranding, modifying branding, these are all critical. Now, why is this a problem that developers are creating? Because they're not telling new franchisors that they may not get trademark registration. What's happening? They're treating the process as a pro forma process. They're not even educating new franchisors or entrepreneurs like you who want to franchise their business. They're telling you, we're going to file for your trademark registration or have our attorney file for it. And then you hear nothing else. You think everything is good. They're not conducting a search. They're not evaluating your marks. If you have outside legal counsel, they're not getting paid because this developer is getting a one fee and doesn't want to pay the lawyers. So no one is telling you or alerting you ahead of time, 10 months ahead of time, that you may have a trademark issue. It's a problem because if 10 months from now you sell 2 franchises and you hear back from the developer or an attorney who says, hey, yep, we heard back from the government, we can't register your trademark. What do you do next? And I know this is happening. I've seen some franchisors, new franchisors, and I feel for them. First of all, they probably weren't ready to franchise, but they have a name that I know will never get registered. Either because it's generic and it's not capable of trademark protection, in which case someone should have told this new franchisor that we need to rebrand or enhance the brand, or 2, it's such a common name that you know they're not going to obtain registration. No one's telling them this because this developer, again, not all of them, just wants to get paid up front, franchise your business. They're not worried about you long term. Number 3, your territory structure is leaving you legally exposed. And give me a little time on this, or maybe not. At a most basic level, developers will talk with you, and we model this out all the time, right? If you're a retail-based business, traditionally, your franchisees are granted an approved location. Once the location's approved, a radius around the franchisee is granted. They're given a protected territory. If you're a service-based business, well, you're given and you provide mobile services at customer homes, for example, well, you're granted a operating territory and your franchisee is authorized to operate within the designated territory. That's pretty straightforward. And it seems to me that many developers, they don't get beyond that initial analysis. The problems we see that come up, let's use 2 examples. Number 1, on the retail front, say I'm selling product. Well, the territory structure is set up, the franchisee's granted this territory. Does that mean me as a retailer or a product manufacturer or seller, can I deliver product to customers that order directly online into that territory? If I do I pay compensation to the franchisee? What if I want to private label another brand? Can I sell and distribute that brand nationally, even if it falls within the franchisee's protected territory? do I reserve these rights? So when we look at territory structures, not only are we setting them up to be competitively positioned and properly positioned for a franchise sales and operational standpoint, but we also consider from a legal standpoint reserved rights. So even though we're granting the franchisee a designated or protected territory, what rights do we reserve to ourselves? And it's critical that when we're granting these territory rights, we reserve the ability to acquire other companies or competing businesses that operate within that territory, that we clearly define our ability to sell product through alternative channels of distribution or through e-commerce, um, that we have the ability to private label or sell through different distribution channels. This comes up often and it's completely overlooked. And then we see successful franchisors, they get out of the gate strong. 3 years later, they have problems because they never intended to give the franchisee certain rights as to other distribution channels or other products or private label. And now they have a legal issue where the territory rights they granted the franchisee are much broader than they should have granted. And it's an unintentional problem and it's a big problem. And developers are causing it because they're pretending that they should be deciding how territories are set up. They're overrunning the legal process or the lawyers they work with, and no one's doing a deeper dive into the future of the business. So not only is this a legal problem, it's also a business planning problem. Now, also on this territory front, when we talk about service-based businesses, I operate within a designated territory. Um, how do we set up territories? I see a lot of developers, they're lazy. They just give a territory. They don't define it clearly or they don't create multi-territory options. So if you're a service-based business and you're operating right now in a territory of 2 million people, well, maybe you're really operating in the equivalent of 3 or 4 territories. So we need a structure and multi-territory offering. It needs to work legally and also from a franchise sales and development perspective. We see this mistake happening often, and it creates a lot of legal problems because keep in mind, when you're talking about territory structures, it's not just here's your radius, you're giving rights to that franchisee, and you need to be very cautious what rights you're reserving. Even, for example, for restaurants, if I grant a territory to a franchisee, does that mean another franchisee can't deliver product in there? What if there's a third-party delivery service between 2 adjoining franchisees? We don't control the third-party service. So what if an order comes in through franchisee B from a third-party service and it's delivered in the territory of franchisee A? Can the franchisee sue us? Are we obligated to stop the third-party delivery service? How did we reserve our rights? What do we say in our legal agreements? How do we plan this out? They're overlooking this. So that's number 3. Number 4 is your royalty structures. I mean, royalties could be straightforward. They definitely need to be baseline based on industry. Restaurants, for example, typically 5 to 6% of gross sales. Service-based businesses vary, and they'll vary depending on an analysis of your economic model, and we go through that in detail. But one big mistake I see is there's no flexibility. It seems like people are lazy. So let's take a service-based business. You have a percentage-based royalty structure. Well, what if a franchisee buys multiple territories? 6% and they don't perform. They don't do anything. 6% of $0 is zero. Your royalties are zero. Well, what we see is developers and their attorneys will say, well, we'll put in a minimum sales requirement. So if I'm a franchisee, I'm not performing well, you'll tell me, hey, Charles, you didn't hit your minimum sales, so we're terminating your franchise agreement. That creates conflict because now the franchisee will claim that you're not supporting them. They'll get a lawyer, they'll sue or you'll sue, and you have conflict. As opposed to a thoughtful royalty structure says, hey, we're percentage based, but we have certain minimum royalty requirements. And no matter what your sales are, you have to pay these minimums. In that case, underperforming franchisees, rather than you terminating them, they may come to you and say that they'd like to give back a territory or give back their franchise. The idea being avoiding conflict. And that's critical. But the developers, they don't know what it's like to enforce an agreement or what franchisee attorneys are going to argue, or really even what state franchise relationship laws say. And so, with your royalty structure, we want to develop that at a deeper level. Minimum royalties. If your business is seasonal, do we have a seasonality adjustment? And how are the mechanics of all of this built into your franchise agreement? The fifth mistake that developers are making, I can't tell you how many times a developer produces a website for a new franchisor and proclaims all these great advantages, but none of it's in the FDD, or in particular, item 19. Example being, at a conversation with a restaurant franchisor, go to his website, it was generic, it was bad, but it said high profit margins. You go to the FDD, they actually had negative profit margins, or certainly not high profit margins. So they're not correlating these things. And the item 19s many times are just very generic, or duplication of data. And there's no deeper dive into KPIs. Now, why do we dive into KPIs? Why do we as lawyers and our franchise development team look to provide detailed item 19s? Well, it helps with franchise sales, right? We want to provide gross sales data, gross profit data, and maybe disclosed expenses and KPIs about select performance points. That's critical for sales, but it's also critical for protection. The more data, the better the information is defined and provided, the more insulated you become as a new franchisor from claims that you gave improper or illegal financial performance representations. So we want to get that down. So these legal mistakes, these developers, again, not all of, they're just not qualified to do what they're doing. And they're producing a cookie cutter product that is either being rubber stamped by their in-house attorneys, which becomes meaningless, or is outsourced to lawyers that are probably underpaid and I'm not doing anything wrong per se. And things may be legally correct, but there are mistakes nevertheless that are going to impact the future growth of your franchise system. For example, in the scenario with a retailer, if a lawyer reviews the FDD, technically it may be correct. He or she may say, well, no one told me that you as a new franchisor have private label products, or want to reserve rights to alternative channels of distribution, or that you needed a more innovative royalty structure. And certainly with the trademark, they file a trademark, but it's not connected. See, everything needs to be connected for a holistic approach to what's going on in your legal and development. And that's why we do both. That's why we've built in, because it matters to me very much if your trademark doesn't get registered 10 months from now, but to the developer, not so much. So those are the 5 mistakes: no attorney, trademarks off track, territory structures that are going to become a problem that may inhibit your future growth, royalty structures that don't scale and almost antagonize franchisees for litigation. And your item 19 doesn't align with your sales materials and your growth strategy. So avoid these mistakes.